questions or comments. So we are honored to have Dr. Andrew Maas here with us. Uh, he is the Associate Vice President for Research and Technology Transfer Director from Office of Innovation and Technology Commercialization. So welcome to our student retreat, Dr. Maas, and we are here to listen to your speech. Thank you.
Let's see, can you guys hear me?
Yeah.
Okay, perfect. All right, guys. Thanks for inviting me to participate. As was mentioned, I'm the director of the Office of Innovation and Technology Commercialization. And as was mentioned early on in the conversations today from Dr. Kansari and Dr. Ramu, we are looking at ways to commercialize and communicate the benefits and the values of the inventions or the things that you guys develop as researchers. So we're going to talk a little bit about intellectual property. A background about myself: I'm an engineer by training. I have a bachelor's and a master's degree in engineering. I worked for 5 to 6 years as an engineer. 5 of those I was in my own company. I ran a startup company. We grew from 2 people to 14 people in about a year and a half. We got to a point where we were doing about $2.2 million of revenue annually. It was a great time. I had a blast, but you actually have to be thinking more than just engineering or more than just science as an entrepreneur. And I felt like I could give back more if I was able to influence more individuals in that space. And so I ended up selling my portion of the company back to my partner, and I went to law school. So I also have a JD and an LLM in intellectual property. Many of you are from universities here in Louisiana. Each of your institutions has an individual like myself who works with the researchers at your institution to help process and develop the intellectual property that you guys are developing. Let's see here. All right. Several types of intellectual property. So a couple things. I have my chat screen open here just to the left of me. So if you have a question or want me to stop or have a comment, just type into the chat and just say, hey, comment, question, or whatever. That'll cue me to slow down or to pause or to ask you to voice your question at that point. Several types of intellectual property that we talk about and often are referred to: patents, copyrights, trademarks, trade secrets, and then there's a whole slew of other types of intellectual property. Ultimately, the main types that you guys are probably going to be concerned about in your careers, whether you're in academia, or whether you end up going into industry, is those of patents and copyrights. Trademarks will be discussed a little bit, and trade secrets, but mostly patents and copyrights. So let's talk about patents. What are patents? Patents are for inventions. These cover novel, useful, and non-obvious ideas that are directed towards a process, a machine, a manufacturer, or composition of matter. And then there's a component there that's referred to improvements thereof. So a lot of people don't realize this, but if you go and buy a bunch of pieces of equipment off the shelf, let's say you go to Best Buy or wherever, and you buy a bunch of pieces of electronics, and you assemble them together in a way that they've never been assembled together before, and it does something really cool, that can get a patent on it. Now, the other patents that might be on the things that you purchased will also be protecting the component of your device, but you have the patent for the device that you have. A patent is actually a negative right, and it has its roots in the Constitution of the United States. Every other country in the world also has some form of patent law. What we're going to be talking about here today is U.S. patent law. There's some nuances between the other countries' laws and our laws, but mostly they're all modeled after the U.S. System. And the reason it's called a negative right is it's the ability to stop someone else from doing something. Normally, a right gives you the permission to do something, where a patent right gives you the ability to stop someone else from making, using, selling, offering for sale, importing, having made, having sold, right? All of those linkages to the patent control that. It's owned by the inventor or his or her assignee. Most employers would require you to assign your rights in the patent to the company. At universities, it's similar. When you are funded or using the university resources, the universities under federal laws are actually required to have the inventors assign their rights to the institution, and then the institution works to help commercialize those and develop those. Patents have a duration of 20 years. That duration is set by Congress. At one point it was 21 years, it's now 20 years. It fluctuates, but ultimately it's going to hover probably around 20 years forever. So copyrights are for works of authorship. So this is a distinction here. It's not for an invention. It's for an original expression of art, music, literature, design, things that you would essentially be able to display in one way or another. Copyrights attach, or you have a copyright attached to an item the moment you reduce it to a tangible medium. So the legal language says once it's reduced to a tangible medium. Reducing it to a tangible medium can be scribbling it down on a piece of paper. It can be typing it into your computer. That affixes a copyright to it. You can register a copyright federally, but it's not required to have copyright protection. And this gives you the exclusive right to reproduce, perform, display, distribute, make derivative works. And this is owned by the author or his or her assignee. Now, this is where it's different from patents, in that most companies will require you to assign your rights in your copyrights to the company. So think of if you were a artist for Disney. Well, Disney makes movies, and those are things that would be copyrighted. Disney absolutely has to own those. They can't have their artists own those. And so the artists for Disney assign their copyright to the company. Now, at universities, most universities release or give back to the authors their rights in anything that they produce as a copyright. And this is because we want our inventors and our researchers and our faculty and our staff to write papers, but we want them to publish. And so we want them to have the permissions to be able to go publish their work, share that work and disseminate that knowledge. Because what's our purpose as an institution of higher education is to disseminate knowledge, to educate people, and to improve the society. Durations of copyrights, they last for 70 years plus the author's life. So you might have remembered some scenarios recently where the estate of somebody has sued another person. I'm thinking specifically of Robin Thicke. He wrote a song, Robin Thicke and Pharrell Williams, they wrote a song called Blurred Lines. Well, they agreed, or they accepted the fact, or admitted the fact that they took some of the music from Marvin Gaye's songs. And so the estate of Marvin Gaye sued Robin Thicke and Pharrell Williams, and the estate won. And after that happened, you didn't hear that song, Blurred Lines, anymore, because it was an infringing piece of copyrighted material. It was infringing copyrighted materials, and therefore they needed to stop playing it. Trademarks. So trademarks cover brands and logos. They cover the name, the symbol, the picture, a sound, a smell associated with a company. The purpose of a trademark is to tell you the source of goods. If I go to a store that has a big M, yellow M outside, and it has these golden arches, and I want to buy a burger or French fries, I expect the quality of that food to be what has come to be known with McDonald's. If it's somebody else and it's sort of, it ends up being junk food, right? Or bad food that I don't like, I'm gonna question the quality of the source. And ultimately the brand value is really based off of how much it's used in commerce. And it gives you the ability to stop others from stealing your brand. So if somebody else came out with, McDuff's, and it was a burger restaurant, and it had a gold arch, gold M arch on it for their burger joint, McDonald's is probably going to go shut them down and sue them because there's a confusion that would occur if somebody went to the burger restaurant McDuff's versus the burger restaurant McDonald's. This mark is, the trademark is owned by the company that it's associated with, and it lasts forever. So I did a lot of work in my studies about what are things worth? What's the value of intellectual property? And the most valuable pieces of intellectual property in the world right now are trademarks, brands that are associated with companies, because they last forever and they can build value over long, long periods of time. Where patents, 20 years, copyrights, the life of the author plus 70 years, there's always a limited time on those things. So trade secrets. Trade secrets are for anything that would be valuable if it's kept secret. Most companies will maintain their customer list as a trade secret, but there's a lot of other things that can be maintained as trade secrets. So like the recipe to KFC chicken, the formula for Coca-Cola, right? So these are some of the classic trade secrets. For those in Louisiana, obviously we have Raising Cane's, the sauce that Raising Cane's uses, right? They won't tell you how they make it, but they say they make it every day and it's really good and people love it. They go there just for that sauce. And you can find places online that are going to give you some sort of a knockoff version of it. Ultimately, people have to know how to make it, but they sign some sort of an agreement with their employer that says, I'm not going to disclose this and try to sell it in a way that would influence your business practices. This is owned by the secret keeper, so either the company or the individual, and it lasts forever. There is this esoteric law in here that says if you use an illegal or outrageous mean to acquire it, the person that holds the trade secret can sue you. It has to do with a guy that had a private airplane and he flew over a chemical plant every day, and he took a picture from the sky. And by taking a picture from the sky, he essentially was in public airspace, but he was creating a time-lapse video of what they were building. And by doing that, he then went and tried to sell it to a competitor, and he ended up getting sued. And the court said, well, that was an outrageous means to acquire a trade secret of how to make the product that they were making in that chemical facility. And they barred that transaction. So ultimately, there's some nuances on all of these. Trade secret has a federal law that covers Federal Trade Secret Act. There's also trade secrets that are managed by state or state-specific common law. So if there's been lawsuits about it in the state. Same thing with trademarks. Trademarks are registered federally. However, there's also state trademark laws that you can engage as well. Here's just a quick summary of the patent types. Everything on here I've already covered except for that bottom row, which is the cost to file some of these different types of intellectual property. Patents cost several thousands of dollars to file. Copyrights, $35 to register, but you don't have to register a copyright because it affixes when you reduce it to a tangible medium. If you want to sue somebody for taking your copyrighted work and using it inappropriately, then you have to register it federally because you're suing them under the federal laws. Trademarks, it's $350 per commerce use. So Apple has a bunch of trademarks in electronics, web content, hardware, music delivery, music streaming, TV streaming, right? So they have it in all sorts of different categories. There's somebody else that has the exact same brand called Apple, and it has a very similar logo in clothing. So they're Apple Clothing, and they are not the same company, but they're different industry sectors. So they're never going to get confused with one another. You're never going to buy an Apple t-shirt and think that it was made by the electronics company, or an Apple computer and think that it was made by the clothing company. So trademarks are really about that potential confusion. And then trade secrets, you don't want to file, you don't want to put them out anywhere, you don't want to place them anywhere, and you want to keep them secret. Other types of intellectual property that we have, right? We have plant variety protections, industrial rights, moral rights, graphic indications, mask works, and database rights. These are, like I said, esoteric, but meaningful. So geographic indications. If you live in Georgia and you want to sell peaches, you can sell peaches that are grown in Georgia and put on them Georgia peaches. But if you sell peaches and you live in Louisiana, you can't claim that they're Georgia peaches, right? Because that would be misleading and based off of geographic indications. These also align with, California raisins, California almonds. There's a big debate right now about champagne, that certain types of the grapes that are grown in that region is what creates champagne, but other people are now growing those same grapes elsewhere, but they're saying, well, champagne is based off of the region, not based off of the type of grape. And so that's an argument going on. When computers started to get involved, they realized that they needed to come up with a protection for what's called mask works. So when the way you make a computer chip, and it's, the wafer fab facilities, is you create maskings. So you put down silicone, you then put down a mask on top of that, and you sputter spray, or you spray gold or silver or whatever the conductive wiring is. You peel the mask off, and then you put another layer of silicone, and you do that to build up these wafers. Well, if you spend a lot of time, energy, and money to develop a really powerful computer chip, and then you sell it in a computer, the first person that sold their chip in a computer, their competitor went and bought the thing off the shelf and delaminated the chip. And by delaminating the chip, they could determine exactly how they built it and what they did in the chip. So they said, no, we have to protect that. That encourages people to invest time, energy, and research into developing better electronics. Some of these other ones we could talk about if you're interested. So the question becomes, what is patentable? Well, there's sort of four criteria that you have to satisfy. Patentable subject matter, it has to be novel, it has to be useful, and it has to be non-obvious. So we're going to talk a little bit about each one of those. There's three types of patents in the US. There's a utility patent, a design patent, and a plant patent. Most patents that you think of are utility patents. Design patents are for purely aesthetic creations, and plant patents are for asexually reproduced plants. Plant patents are different from plant variety protection. So plant variety protection is for sexually produced plants, where plant patents are for asexually reproduced plants. And then design patents are for the look and the feel of things, the shape of something. So often, you've probably heard of Samsung and Apple suing each other because of their design of their phone, of the shape of their phone, or where their button resides on their phone. But usually we're talking about utility patents. Here's the US law that gives the rights to patent holders. And again, these are the things that are covered: a process, a machine, a manufacturer, a composition of matter. Several things are not patentable. Laws of nature are not patentable. Products of nature. So if you take something and isolate it, DNA strands or something, and you just isolate it down to a very specific set, and then you turn that into a therapeutic of a drug, that by itself is not patentable because it's naturally occurring in nature. If you splice it with something, then it becomes patentable, but beyond that, it's not patentable. Scientific principles or theories, abstract ideas, mathematical algorithms. So mathematical algorithms are not patentable by themselves, but if they are linked to a machine, like a computer, then they are patentable. So there's a fine line about, software algorithms being patentable or not. And software is actually unique because software is protected under copyright because you wrote it down, but it's also could be protected by a patent if you filed for it. The problem with filing software for a patent is, one, it takes a long time to get the patent, and two, you have to give up all your information. You have to tell everybody all your secret sauce in your algorithm, where if you keep it as a copyright, you don't have to tell anybody about it. You don't have to register it, and you can compile your software so that it's encrypted, so nobody knows your actual steps in your algorithm. You can't get a patent on illegal objects, aesthetic creations, because those are covered under a design patent, and atomic weapons, the federal government doesn't want anybody else being able to tell anyone else in the US who can and cannot make atomic weapons. So let's talk about those three standards. Utility. So this is really how to use the invention. This is actually a pretty easy standard to meet, right? Lots of things have utility in one way or another, and it just can't be frivolous or illegal. It can't, clearly be something that would be um, inappropriate in, like this transgenic mouse for use as snake food. So novelty is something that's really important for you guys to understand. So novelty deals with, has this invention been disclosed before in the public setting? Printed publications, journal articles, if you share it in a conference proceeding, um, filing a patent on it, right? That, or public knowledge or sale. Those are all things that would destroy the standard of novelty for your technology. Your own disclosures can serve as prior art against you. So this is why if you're going to share stuff with a company or with an industry partner, we often encourage you to get a confidentiality agreement in place. Doesn't mean you can't talk to them about it. But what I tell my inventors at LSU is I say, if you're going to share something with a company, don't talk about your secret sauce. Don't talk about what the unique invention is. Talk about the results you're getting. Results are, ultimately are not part of the patent, because that's not the invention. In the US, we actually do have a 1-year grace period that says if you disclose something today and publish today, and it gives all the information about your invention, in the US, you have 12 months from today to file a patent and still be able to get patent protection in the US. Other countries have what's referred to as absolute novelty, which means that if you publish something today and you try to file a patent tomorrow in China or in France or in Germany, they're not going to let you file a patent because you published it the day before. Well, they'll let you file and you can spend money trying to argue it, but ultimately they're going to reject it because it's already published. So this is why it's important to have non-disclosure agreements in place. This protects you and it protects your institution. Having a non-disclosure agreement is different from stamping confidential on the things that you share. Having a non-disclosure agreement or a confidentiality agreement actually is a contract between your company or your institution and the company you're sharing it with that says, if you break this, there are consequences if you break this relationship. Where just stamping confidential doesn't really have that same weight. All right, so the third standard that you have to overcome is what's called non-obviousness or unobviousness. So let's say, for instance, there's two inventors or two researchers. One researcher is an expert in toasters and the other is an expert in ovens. And I develop the toaster oven. I do a bunch of research. I develop this toaster oven and I file for a patent on the toaster oven. Well, the patent office is going to take all of the content in the world associated with toasters and all of the content in the world associated with ovens. And they're going to say, yeah, but having, a person having ordinary skill in the art, if they knew all this information and they knew all this information, it would have been obvious to them to combine these to come up with your invention. So it's sort of a hard standard to overcome, but there's ways to do it. And working with your patent attorneys is helpful in overcoming these and crafting arguments with the patent office to overcome their rejections. A lot of people, when they get a patent, they don't realize this, but patents are examined with the patent office. There are examiners. This is also another route of career that a lot of scientists take if they at some point become disenchanted with benchtop or lab type activities. They end up examining the technologies and they apply the standards that the law has set, and they then usually will reject a patent for several times through. A lot of inventors get frustrated when they get a rejection. And the reason they get frustrated is they feel like they're being rejected similar to how you're being rejected when you submit a paper or a publication. In this scenario for patents, it's not the same thing. Essentially, they're trying to set the boundary of what is already out in the world. And I actually make the statement that if you get a patent immediately when you file it, then your invention didn't encompass enough of your idea, right? And so I talk about it sort of like blowing a bubble. You want the bubble, when you file a patent, you want the bubble to completely encompass the invention. You don't want it to leave something out. And then you want to let the patent office come in and say, well, that's not part of the invention because something else is out there. And this over here is not part of the invention because something else is out there. And you want the patent office to change the shape of your bubble based off of other things that are being brought in, versus you trying to arbitrarily manipulate it based off of what you think is out in the world. It also strengthens your patent, I think. So here's a fun little cartoon that I like to just share about, what does the first law of inventing say? You have to have usefulness, easy to overcome, novelty, easy to overcome, and then that unobviousness or non-obviousness is the hardest hurdle to overcome to get your patent. Any questions to this point? Just checking the chat here. All right. So a couple things that we want to clarify, right? If you disclose your invention to the institution, this is not any type of patent protection. This is just starting the ball rolling in your institution to say, I have an invention. The institution may file a patent. There's different types of patents. The first type of patent that you can file is a provisional patent. That establishes your date and time to say, here's my invention. Beyond that, 12 months later, you would have to make the decision, or the institution would have to make the decision to convert that to a non-provisional filing. As long as it's provisionally filed, you can say that that item is patent pending, right? It's awaiting for something in the patent office. After 18 months from the first date of filing, the patent becomes published. So you have to make a decision if you want to keep it going, and if you keep it going, then it's going to become published. But this is before you ever get a patent. So you're giving up all of that information by publishing it or having it published in the patent office, and you may never get a patent on it. So that's part of this this exchange that the federal government has set up, is you have to give up your information for the chance to get a patent, okay? If it's been issued, that means that the patent office has reviewed it and found it patentable, and then that is enforceable in a court of law. During the life of a patent, you have to pay maintenance fees. There's a 7-year, 9-year, and an 11-year maintenance fee. If you don't pay the maintenance fee, then it becomes an abandoned patent, which means that it's no longer protected under patent protection. If it runs all 20 years and you pay all of those maintenance fees, then it will become expired. And that means that it was patented at one point in time, but it is no longer patented. So then the question becomes, who is an inventor, right? So inventors it's a legal term, a legal definition. We use our attorneys to make the determination of who is an inventor. So those that contribute to the invention and the concrete part of the idea can be an inventor. It's not the same as being a co-author. It's not the same as being the authors on papers, because authors on papers can be you can give authorship to somebody out of just love, care, and respect for somebody that's in your lab, or they could participate and just edit the document, and you might give them last authorship on the author, or the laboratory lead always has last authorship or whatever. That's different than inventorship. So this is where it's important for you to fully disclose who did what and why it's important to keep good lab notebooks, because lab notebooks will indicate, well, who really did what and when. And 2 or 3 years down the road, it's often blurred as to who came up with that kernel of invention. And that's when we're going to need to know it. So those lab notebooks are helpful. There's different parts of a patent. Obviously, there's a cover page. There's the specification. The specification is sort of written like a journal article. And then there's the claims. The claims are the boundaries that constitute the legal outline of your invention. Similar to if you own a piece of property or you buy a house, there's what's called the metes and the bounds of the property. So it defines, you know, starting from this corner, going this direction for so many feet to the corner, right? So that's the definition of your legal property on land. The claims are the definition of the legal property in a patent. So there is no such thing as an international patent, but there is the International Patent Cooperation Treaty. So so far 151 countries have signed on to it. Essentially, all the countries say we will recognize that country's filings as if they were our own if that patent application gets brought into our country. So if I file in the US today and then I want to file in Germany, I can file in Germany within 30 months. And Germany will still acknowledge that I filed today as my date in time for Germany, right? So it's just a way that we can sort of align different countries across the world to file for, you know, to protect things in commerce. There is a federal law called the Bayh-Dole Act, and this was passed in 1980, and it was essentially stated that universities will own inventions made with federal research money. It really focuses on promoting commercialization of research and engaging university industry collaborations. Here's a graph on the side that shows you how many patents have been issued to universities since 1976. So you can see that there's been a steady increase since 1980 when this law was passed. That activity really comes down to our institutions are under a federal mandate that if we receive federal money and somebody invents something based off of that federal money, that we have to try to commercialize it. By trying to commercialize it, that is, how does it get used in commerce? How do we license it out to a company? If there's revenues that come in because of it, we have to benefit or we have to pay part of those royalties back to the inventors. So there's some financial benefit to this as well for inventors across the university. Here's just a very busy slide of all sorts of things that have occurred because of Bayh-Dole. 11,000 startups have formed since 1995. So a lot of people look at researchers and they say, well, why don't you start a company around your technology? Well, you could. And that's where I would encourage you to work with your tech transfer office and understanding what you can and can't do. There's ethics obligations in Louisiana that you have to make sure you abide by. So work with the university and the institution to make sure that you're in compliance with all the rules and regulations of your institution. So, you know, we talked about the patent process, disclosing, filing a provisional potentially, and then filing a non-provisional, and then we start working with the patent office. So a few comments about that. Filing a disclosure does not automatically provide protection, right? Our tech transfer offices across our institutions will try to work with you once you have filed disclosure, and we need the inventor's involvement as we go through that process. It's not like a dry cleaning service, right? You can't just drop it off and somebody else is going to do all the work, and then you're going to come back three years later and get your patent and start collecting royalties. It's got to be a collaborative activity. I wanted to give you guys a real quick, I'm just cognizant of time, I wanted to give you guys a real quick rundown of a prior art search and then talk about I-Core a little bit. So prior art, you know, gives you the understanding of whether something's patentable, but it also tells you whether you can actually make, use, and sell the thing that you're making, that you've invented. Patentability essentially just looks for usefulness and novelty and non-obviousness to see if it would meet those criteria. Freedom to operate checks to see if there's somebody else out there that might have an invention that could prohibit you from practicing your idea. Those are both processes that usually attorneys do. They're expensive, but they're sometimes valuable as you're going through the commercialization process. Again, we talked about the sources of prior art. So how do you do a patentability search? You want to find things that are similar and different in all types of product, in all types of materials out in the world. Usually we start with patent work, patent content, because that's usually the easiest to source. I use Google Patents because it's pretty easy. It's intuitive to most people. you can go in and you can use their keyword searching that helps you find things. And they have a component in there called reference by and citations too, or patent citations. Those will give you links. And I'm going to just run through a real quick example here. Let's say Dan, he was an intern for me at a previous institution. Let's say he developed a golf training device in his basement that rests in your armpits and attaches to the putter to make your golf swing more pendulum style. Can Dan obtain a patent on this device? So I go to Google Patents and I just type in Google putter attachment, and I come up with some hits. One of the things that comes up as a hit is this golf putter aid and brace member thereof. Okay, so I start reading the abstract. I'm like, oh, look, this is just like what Dan said he has invented. And so then I think, okay, well, let's look at these other two lists, the patent citations and the reference by. So patent citations, as you file for a patent, you have to cite other patents in your application. Those are all things that are back in time. Reference by are anybody in the future that referenced your patent application or your patent publication as something that was prior art to theirs. So you can quickly drill in and out. So here's the patent citations. I find one, that says golf training device for teaching pendulum type putting swing, right? So I can quickly drill in and out and find things that are relevant. And here's that invention. And I'm like, well, that's exactly what Dan has invented. So we're probably not going to waste a lot of time, energy, and money trying to file for a patent on this because we see a bunch of prior art out there. Any reference can serve for prior art, and they can stop you from getting a patent, including your own journal articles. So if you have a white paper or a manuscript that you're getting ready to file and you think you're getting ready to submit to journals and you believe that it discloses your invention, that's where you need to go and talk to your tech transfer office at your institution. And the last item I'm going to cover in 2 minutes is a program that I run at LSU called the National Science Foundation I-Course Sites. National Science Foundation, who funds a lot of research across the US, back in 2010 realized that they needed to help a lot of scientists that were receiving the money from NSF to apply that technology in real world applications and show how it would be useful for society. So here's an example, right? NSF has a $7.5 billion budget. This was from 2019. Their budget is potentially going to go up based off of some of the new laws that are coming into place. But they wanted that $2.5 or $7.5 billion to lead to measurable outcomes. And not to say science research isn't it's not bad, but there's a lot of money that's spent on things that end up creating just scientific oddities or aha wow moments, right? So for example, we have here in Louisiana LIGO, the Livingston Observatory, where they observed gravitational waves. Amazing science going on out there. A lot of money has funded that activity over the last 15 years. That technology, I'm willing to bet that sometime in the next 15 years to 20 years, that type of information is going to drive technology in our computer chips in society. But again, using that technology for that purpose is trying to figure it out is what NSF wants to see that science being used for. So there's really two main programs that NSF runs. They run the CITES program, which is what I run here at LSU. Our CITES program is open to anybody in the state of Louisiana that wants to receive the small $3,000 grant to understand how to commercialize their technology. The nodes and the hubs occur regionally, and they have small courses that also help participants or scientists understand how their science might have application in real commerce. And then those two programs actually qualify you for what's called the Teams program. And this is a $50,000 grant that provides a 7-week training program. They expect 15 to 20 hours a week of time from everybody involved. And It helps you identify customers and customer segments. It also increases your chances of getting SBIR and STTR funding if you do spin out a startup company. Here's a summary of things. The only thing on this slide that is specific to LSU is this LIFT program right here. But the I-Core Site program is really to explore market opportunities for your science. That's run through my office. If you're interested, I'd love to have you involved. We're going to be running a virtual cohort in the fall. The next two programs are the I-Core Teams program, which is a national NSF program, $50,000. Also, an organization called Venture Well runs a similar program for validating the market opportunity. And then to validate your technology, to create the proof of concept, LSU has this prototyping grant called LIFT, and the Board of Regents has a prototyping grant called the Board of Regents POCP Fund. So you can, over time, have $50,000 to $100,000 geared towards exploring the commercial opportunity of your technology. This is all before you start, spin out a company or think about spinning out a company. Once you do spin out a company, then you can go and apply for SBIR and STTR grants. Phase 1 is up to $225,000. Those that participate in these programs, the I-Core program and the LIFT program, are 3 to 4 times more likely to get an SBIR grant if they spin out a company. And I think I'm over my time, but I will end there with any questions or questions that you may have.
Okay, thank you, Dr. Maas, for the great presentation. We are waiting for other people to ask questions. So while you're waiting, I have a quick question. So do we any kind of service or consultation service or some office? Suppose I have an idea. Can I go there inside the campus or in LSU and ask for consultation from you?
Yes, yeah. So if you are, so let me comment on that. If you're an LSU student, then we can definitely help you on our side. If you're a student at another institution, Louisiana Tech, they have their own office. UNO has their own office. So the other institutions that are part of SIM have their own offices. If they're unable to support or have the right knowledge or bandwidth, I'm happy to help, right? I'm here to help improve and benefit all of Louisiana. While I am employed at LSU, I want to see things be successful across the state. So.
Okay, thank you so much. Because there are lots of issues in my head that are not addressed in your presentation, I might need some other questions. So anybody welcome to contact you. So thank you for the great presentation. So everybody, we are a little behind the schedule. I think we can have a coffee break now. So we will be back at 10 o'clock.